ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్ 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్ 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
Boomi Instant Coffee is made with 100% pure coffee beans guaranteed. It tastes and smells like fresh brewed coffee without the weight. Our proprietary low-cycle extraction process maximizes the flavor and aroma, making each sip equally delicious. We're committed to serving you affordable 100% pure coffee with no additives or artificial flavors. Try a cup and join the millions worldwide who enjoy Boomi every day.
Sunshine Wealth LLC. Conquer your financial future.
We came to this country with big dreams. We have been working day in, day out. Our big dreams seems impossible to reach.
TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome to yet another fantastic show about the talk show with our experts. మనతో మన ఎక్స్పర్ట్ ఉన్నారు రాహుల్ రెడ్డి గారు. రాహుల్ గారు, thank you so much for being on our show today.
Thanks for inviting me, Garu.
And looks like we have another explosive topic. ఇవాళకి అన్నమాట. We have our main topic for today is going to be discussing about the increase in wage levels for the H-1B folks. There has been some new interim H-1B regulations aన్నమాట. So what exactly is going on? Does this mean like the end of H-1B? Because this seems to be like something that would create a significant impact to companies even wanting to do H-1Bs. So can you elaborate on that, sir?
According to the chief of the USCIS, this will be the end for 1/3 of the H-1Bs. The target is 1/3. So that's his official statement. He made it when he's responding to the Congress, that this will be the end for 1/3 of that. There are two things here. The Department of Labor, prevailing wages, and H-1B interim regulations. So I'll describe about the Department of Labor thing. The Department of Labor comes with the new prevailing wage that increase the prevailing wage in most of the locations by about 30 to 40%. So let's say, for example, in a city like Dallas, the prevailing wage was $75,000. Now it's almost like $106,000. So things have gone drastically increased in almost all the city. I would say at a minimum of 25% to a maximum of almost like 45 to 50% prevailing wage have gone up for almost all the H-1B occupations. That went into effect on October 8th.
Okay.
And what happened is that the applications that are the LCAs that were being received before, the labor condition application that is needed to file for the H-1B,
Right.
they will be good to use the previous LCA. But if any LCA has been filed after October 8th, then they will be subject to the new dual wage rates.
Oh.
That's one stroke that the Trump administration did it.
Okay.
The second slap that they did was that the H-1B regulations, they changed it. There are two main aspects that they changed it. One is the specialty occupation. They made it very hard to get the H-1B. H-1B should require a specific degree.
Okay.
The position must require a specific degree. So they made it very hard for the people to classify to the H-1B. If there are any doubts that the position requires a specific degree, then they will not consider that as a H-1B and they'll deny that. That's one thing. Second thing was that they were always trying to restrict the consulting companies. Most of the H-1B, the jobs are where the consulting companies place in individuals in third-party locations because of the intense software requirement that the companies have. They need to get an outside help to get their internal things taken care of. So what the administration did is that they put more restrictions on the consulting companies to get H-1B. If by any chance they swim through and get into those things, they will be only limited to get a 1-year H-1B. That means that every time they go to the every year they have to go for H-1B extension. And yeah, so it's as they said it's 1/3. If these regulations and these prevailing wage stand as it is, I would say that 50% of the H-1Bs will be in danger. Obviously, people like me, are collaborating with other people to fight this in the court. There is a good chance that we may win because the way the interim regulations, there was no notice and comment. They passed the regulations, made it effective, and then they said it will be effective 60 days from now onwards, and you can comment right now. Well, when you already decided, what are we commenting about? Of course, we're going to comment, but still, they already gave the interim regulations, so this is very tough. You want to go for
now, Rahul, why this at this juncture?
But Trump administration wanted to go through the normal regulatory process. That means that to publish it, once they publish it, then there will be a lot of comments. They have to respond to those comments. There are some weaknesses in their things, so they don't want to go through the weaknesses in those things. That's the reason they immediately published it. Could that be, do they have a good stance in the court when we go challenging these things? They'll be very weak in the court, for sure. They know that. Could this be an election stunt where the Trump administration is trying to satisfy the base from which he got elected? That looks to be the main thing, not that this is going to be good standing in the court. That's the way I read it, but we'll have to see. If by any chance court rules in his favor, we are almost doomed.
Yeah, I think that might be the likely scenario, the last one that you said with the elections coming up, that they're appealing to their voter base, which makes sense.
Yes, that's right.
Because they know they're going to be shut down in a court, because this is not something good. So Rahul, I think we have a ton of viewers and callers who are there today. So let's get on to our call really quick. Let's go with our first caller for the day.
Please, all the callers, once you get on, press *6.
To unmute. Hello. Okay. So while we have our caller coming in, let's go to one of our YouTube viewers. His name is 𝗓𝗲𝗪 𝗏𝗃. His question is, hi Rahul, my wife's date of birth is different.
Yeah, I saw that question. I saw the question. It was before the show. If the birth certificate has some deficiencies, for example, if the name is wrong, date of birth is wrong, do not submit the birth certificate. Right now, get 2 affidavits. You can get those affidavits from either India or USA. The drafts of those affidavits are there at rnlawgroup.com. Type in birth affidavit and you will get the drafts of it. It will ask you many other documents. Don't worry about it. You can't get it before this October. So I want you to just get 2 affidavits. Do you have to go to India? Do you need to get it from your uncle? Do you need to get it from... No, just your next door neighbor can give you a birth affidavit. You can give it to him, he can give it to you. If there is any deficiencies. I saw the question on the YouTube too, that the person is asking that his birth has been registered after 20 years. Right now, you submit this birth certificate, you're good. There is about 5% chance that they may raise some questions at RFEs. We can address it at that point of time, because right now, if it's been issued 20 years later on, we can't go back when you're born and correct that system at all. Right now, submit it, and if the RFE comes in, you can contact a lawyer. It's not that hard. I've not seen a single adjustment of status case denied because there is some deficiency in the birth certificate. Not yet. I would say that, instead of submitting the wrong birth certificate, if you have any doubts about it, just submit the affidavits. You'll be in good shape. If the birth certificate doesn't have the father's full name, mother's full name, it's okay. If the birth certificate doesn't have your name at all, I would recommend do not submit it at that time. Do submit it after, just submit the 2 affidavits. You can deal with it later on if they ask more questions on it.
Okay, that makes sense. Rahul, I think we have a caller on. Hello?
847 *6 to unmute.
Hello.
Hello, ma'am.
Yes, ma'am.
We can hear you.
Swati here. I have the one question regarding my H-1B extension.
Go ahead, ma'am.
Actually, I have applied for the H-1B extension on 26th of the September. But after that, my I-797 is expired, and day before yesterday, my I-94 is also expired. I didn't get any receipt number till now. Is my stay in the US is valid or?
Perfectly valid. Perfectly valid. Your FedEx tracking number or USPS tracking number must show that your application must have been received by the immigration. If you don't have a receipt number, it is technically okay. You're legal to stay in the United States. You're legal to continue working for the H-1B extension that was been filed.
Okay. That means if the filed one is reached to the USCIS, that is fine.
You are right.
Getting the receipt.
You are right.
Yeah.
You don't have to panic right now. Thank you for tuning in.
Okay, then. Thank you so much.
Thank you, ma'am. All right, Rahul Garu, let's go to the next caller really quick. Hello? Sir, please press *6 to unmute your line. Area code 813. So Rahul Garu, while we're waiting, there's another user on YouTube saying, can you explain same similar requirements in the... Hello?
Hi, this is Krishna.
Hi, Krishna. Krishna, can you please mute your TV volume?
Hi. Hi.
Mute your TV volume, not your phone. *6 to unmute. Hi.
Yes, good, sir. Waiting for your questions.
My company has initiated my GC process. So 2 months back, and I am in PWD stage. So I heard that this is going to impact my application.
You are absolutely right.
So what are the steps should I have to take now? Do I have to reach out to my employer and ask them to refile my PWD? Or
no, refiling PWD won't make any difference though. So do you meet the requirement of the new LCA requirements? Okay. The new prevailing wage requirement. You can speak with your lawyer though. He can typically estimate what is the position, what is the place at which you are in, would you be okay in that? So if the prevailing wage is expected to be way higher and your company cannot afford it, that will become a problem for you. They may not process your green card.
Yes. That is what even initially they said they won't apply for EB3 for me because of these restrictions. Okay.
That's different. EB2 you mean to say. That's different, and this is going to be a very big challenging thing for you. That is a prevailing wage. What our office is doing is that we have been successfully done alternative wages before, even when this new prevailing wage has not come down. We did it. We have been successful in it. We did for many different companies though. In this new DOL thing, there is no restriction that we cannot use the alternative wages. The problem, there are some slight problems with alternative wages. It may not be applicable to most of the positions. It will be applicable to the most of the positions, but may not be applicable to all positions. So the companies may have to look into, to speak with innovative lawyers to counter this. Otherwise, they can't proceed with the green card application right now. Okay?
Okay.
Thank you.
Okay.
Thank you, sir. Thank you for calling.
Yeah.
Okay. Rahul Garu, let's go on to our next caller. But in the meantime, I have another question for you from a YouTube viewer. He says, can you explain same or similar requirements in the IT industry? My label is senior developer, but now I'm a director of tech research. What should I do when I file the 485?
All positions. So the companies may have to look into, to speak with innovative lawyers.
Rahul Garu, 1 minute. Sir, area code 732, our next caller. Please mute your phone. Please mute your TV volume.
Okay, let me answer this question and we'll go to the caller.
Okay.
Let's go to the first question is.
Hello.
Sir,
Just hold on for 1 second. Same or similar conditions, he has moved to a higher level position, what he's saying.
Right.
It is more a subjective reading of the company and subjective reading of the individual. Subjective reading of the lawyer though. Not much interference is there in the USCIS, not much denials are going on in there. Now, based on what he said to me, that I feel that is a natural promotion in the span of 5 to 8 years. That's a natural promotion. I don't think so that I still think so that they're similar job duties. But if you as an employee feel that it's not a similar thing, there is nothing I can do. I mean, we can't help you. But if you think so it is, your company thinks so it is similar jobs, then USCIS is not objecting that much. Go ahead with the caller, guys. The gentleman I interrupted.
Yeah, no worries.
Hello.
Hello, sir. Cheppandi, please.
Hello.
Yeah. Go ahead now.
Yes, go ahead.
Hello.
Yeah, hello, go ahead.
Hello.
Hello?
You're saying hello,
Can
but
you
you're
hear
not
me?
saying anything.
Yeah, we can
Yes,
hear
we
you,
can.
sir. Go ahead.
Yeah. Okay. Thanks. See, I have just 2-3 questions. So my situation is that last month I moved to company A to company B, but my project had become current. So now I'm moving back to my company A.
Mm-hmm.
But my company B H1 got approved and I moved their payroll. So is it okay if I go again back to my company B, which is
okay. It's legally okay to go back to company and file adjustment of status. Just because you got the I-1 for H-1B approval with company B, it's not prohibiting you to go back to company A.
So company A, that old H-1B is still valid, right? I mean, I can join full time again.
Did they withdraw it? Did they withdraw it? Or
No.
No, it still is valid then.
Okay. So next question is that once I filed I-485, so I can travel, right?
You can travel, but your advance parole will be denied. I will do,
But I can reapply, right?
You can reapply. You're right.
Okay.
It doesn't affect your adjustment of status application.
Okay. Okay, that's fine. And third question is that I had some 6,000-7,000 credit card debit.
Not
which is,
a problem.
Zero,
not a problem.
No, but what happened? I paid that using my friend's checking account. So he helped me to
It doesn't matter if you even have a $20,000 credit card account. If your family income is more than $60,000, you're fine.
Okay, but paying a friend's account is also not an issue, right?
I would not address that. That's not an immigration issue at this point of time.
Okay.
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 Fine.
Thank you, sir.
Thank you.
Can you pay mine too?
I know, we'd all be happy. Rahul Garu, let's go on to our next caller. But in the meantime, so I have a question from Suraj Ram. He says he has an approved I-140 under EB2. Is there any rule where USCIS can reject perm associated with the EB2 category if I apply for the adjustment of status under EB3 downgrade?
So is there any chance? That's a question he said. There is always a chance. I mean, is there any chance I can get a $231 million in a lottery in the next 1 week? Yes. So people need to ask, what are the probabilities rather than any chance? Lawyers will always say, yes, there is a chance. I mean, technically, can I say anything else? Is there any chance that lightning may strike and I might die in the next 5 minutes? Yes, there is a chance. So yes, there is a chance. But the probabilities, if you're working with the same company, to downgrade it to get the I-140 denials are very low. Make a point that if you're still working for the company, the probabilities are very low.
Got it. Okay. Thanks, Rahul Garu. Let's go to our next caller. Hello?
Hello.
Sir,
Yes, go ahead, sir.
Yeah, we can hear you. Please go ahead.
Hi, Rahul Garu. Thank you so much for all your help in addressing these questions. Sir, I have an EB2 prior date March 2013. మా లా ఫర్మ్ వచ్చేసి ఫ్రాగోమెన్ సార్, దే ఆర్ గోయింగ్ అహెడ్ విత్ ద డౌన్ గ్రేడ్, దే ఆర్ సపోర్టింగ్ ద డౌన్ గ్రేడ్. అయితే ఇప్పుడు ఎప్పుడైతే ఫైల్ చేస్తామో సార్, అప్పుడు రిసిప్ట్ నోటీస్ నాకు అడ్జస్ట్మెంట్ ఆఫ్ స్టేటస్ వస్తుందా, లేకపోతే 140 రెండు వస్తాయా సార్?
రెండు వస్తాయి. They will, Fragment is going to file I-140 and adjustment of status at the same time. They will put in the same FedEx package.
Okay, sir. So after once adjustment of status receipt వచ్చాక I'm eligible to apply EAD, sir. వాళ్ళు రెండు ఒకసారి చేయమంటున్నారు సార్. First 485 చేసి తర్వాత you can apply 765.
Exactly. Very nice form. Very big law firm. We are doing the same thing. The reason is that it's too many applications, too short of a time. We want to get the application in there. That's a perfect strategy, very good strategy. As soon as you get the receipt notice of the 485, you can file the adjustment of status. And I know what your next question will be. Oops, what if the priority dates backtrack in November? Oh, well, we are assuming that they will. You can still file a EAD in advance parole. Absolutely not a problem.
Okay, sir. And 140 process will continue to be there. Mostly, as you said, like it will approve because EB2 and EB3 రావాలి. Yeah.
Very, very high likely.
Okay.
Thank you, sir.
Sir, ఇంకొక last minute, sir, 1 second. Credit score కొంచెం యూజ్ చేశాను సార్. సో దాని
మీ ఫ్యామిలీ ఇన్కమ్ $60,000 కన్నా తక్కువ ఉంటే నాతో మాట్లాడండి, లేకుంటే మాట్లాడకండి క్రెడిట్ హిస్టరీ గురించి.
ఓకే. Thank you, sir. Thank you all.
Okay, now I know your income. Okay then.
Thank you, sir. Rahul Garu, let's go on to a next caller, but at the same time, let's finish up with another user here. Mahesh says, at what time frame should one go back to the old employer, assuming immediately going back is not possible after older employer files for downgrade to EB3?
There are two potential problems, Nithya Garu, in this one. First one is that, remember that I told the probabilities of I-140 getting denial are very rare if the person is working for the company. But this guy is not working for the company. So it's definitely a risk point is there for him when he is downgrading. Now, the other question is, at what point he has to go, the sooner the better. Because the immigration is going to look into, is this a genuine job opportunity, or is it just everything done for the adjustment of status? They may look into it. I would advise to move as soon as possible.
Okay. All right. Thank you, Rahul Garu. Before we go to our next caller, to all our viewers, please make sure you limit your questions to one at a time, because we have an amazing number of callers and they all want some of their questions answered. So please try and limit your questions. Okay. Thank you. All right. Let's go to our next caller, Rahul Garu. Hello. Sir, please press *6 to unmute. Hello.
Hello.
Yes, sir.
Are you able to hear me?
Yes.
Yes, sir.
Go ahead.
Yeah. Hello, Rahul. I am Ani from California. So this is regarding for my wife. We applied her H4 and H4 EAD, but we didn't get any biometric done. Later we applied her H4 to H1 status change also, and her H1 is got approved. So what we should do with the H4 and H4 EAD, which is pending now? Because as per my understanding,
got the point. Let's wait. Did the H-1B got approved with the I-94 or without the I-94?
With I-94.
Is this a quota case or a non-quota case?
It is a non-exempt case.
Non-quota case.
Non-cap, okay. Actually.
Okay. So when did her I-94 with the old H4 expired?
So that I-94 got expired October 7th. And
so before that,
October 9th.
Sorry. On October 9th,
he got approved
for the H-1B.
H4 to H1 approved.
Okay. It's up to you. You can keep it as it is. You can withdraw it because she got with the I-94. She satisfies the requirement. You can keep as it is, but once the H4 gets approved, she's no longer an H-1B. She'll be considered to be an H-4. But there are ways to reverse that action. It's called automatic revalidation. She can go to Mexico, have a coffee, and come back. She can be an H-1. And go back to Mexico, come back, and have a coffee again, and come back. She can be a H-4. She can keep switching without going to the lawyers.
And in this case, Rahul, because if there is a gap between H4 approval and H4 EAD,
that's
they cannot
fine.
work,
You
right?
said, I'm sorry, you said that the October 7th and October 9th, you have evidence that you have a H4 application pending. The receipt notice is there, so I don't see any problem. The other thing is that you said very clearly to me that the H-1B was approved with the I-94. The Attorney General through USCIS has approved it. I don't see any problem in it.
Okay, sure. Thanks, Rahul.
Thank you.
Thank you for calling in. Now, Garu, before we go to our next caller, let's take the next caller on, and in the meantime, we have a question from our YouTube viewer, Bala. He says, can I lower my wage level to level 2 from previous wage level 3 for extension?
We don't see that as a problem, though. We don't see that as a problem. I know why he's asking that, but we don't see that as a problem.
Okay, awesome. Let's go to our next caller. Hello.
Hello.
Yes, sir.
Yes.
Hello.
Different. We can hear you.
Hello, Andy. Yeah. Good question, Andy. I moved from employer A to employer B, Andy, like 2 months back. Mm-hmm. And these two are very big firms. Fortunately, employer A, they allowed me to come back. They have an option for me to come back, and they are ready to file a 485J for me. So the problem here is they still need to file a new H-1B. With the new regulations, again, the fortunate thing is the salary-wise, it's okay, but I'm worried about the new rules that are coming up. So let's suppose my H-1B is denied. What are my options of working for employer A without going out of state?
If you file an adjustment of status, okay, and if the H-1B gets denied also, you would be considered to be in legal status. You may not be able to work until the EAD comes in, but you would be considered in a legal status. So when you file a transfer of application right now, what I would suggest you do is that don't file in premium processing, file in a normal processing. By the time they adjudicate this application, oops, it's going to be a long, long time. And if by that time you should be getting an EAD approval. Once you get the EAD approval, you roll that H-1B receipt notice, make it like a football and kick it if you want to.
Okay.
But however,
yep.
If the H-1B gets denied, you would be considered to be married to this adjustment of status application. And if you want to know the definition of marriage, I want you to go back 2 weeks ago with the TVASIA, where we provided evidence what marriage means. Marrying to the adjustment of status. Okay, that's the fault that you will have. You would be considered to have been married to this adjustment of status. But you should be fine. I don't see any problem in you.
Got it. But I can, if the firm files it in premium processing, do you want me to ask them to not to do it in premium?
I don't want it in premium processing because, well, one thing is that the rules of the H-1B are going effect in 2 months. They're not going effect right now. So it may be worth for you. Okay. Yeah, you may want to consider. I may be fine on premium processing, but it's your judgment call whether you want to go in premium processing or just wait for the EAD to approve and file in normal processing. Okay. Thank you then.
Thank you.
Gotcha. Thank you.
We go on to our next caller, but also in the meantime, we have a question from our YouTube viewer, Manju. It says if birth certificate is not available, but can't get non-available certificate, will affidavit is sufficient?
Yeah. If you can get the there are two options for her though. First is not an option. She needs to get birth affidavits. It's easy. I know you go to social gatherings, just have somebody of your friends give an affidavit. They just need to notarize it. They just need to know you're born. That's it. I mean, you are born. Otherwise, you wouldn't be posting that there in our YouTube. So they can give an affidavit. That's one. Number two is non-availability certificate. Now, it's not easy to get non-availability certificates though. So I would say that just file it with affidavits right now. If you get an RFP at a later date, you can at that point of time get a non-availability, or there are alternatives to non-availabilities. you can try to get, particularly if you go to Tamil Nadu, they won't give non-availability certificate, no matter what. Even you go to the court and get the order, they won't give it. So there are some alternatives. At this point of time, to go through all the hassle of non-availability, I will not do it if I were you.
Okay. All right, Manju, if you're watching this, then I hope you have your answer. Let's go to our next caller. Hello?
Yeah, hello?
Yes, sir.
Hello, sir. We can hear you. Please go ahead.
Hello?
Yes,
yeah,
sir.
hi, Rahul. Yeah. Are you able to hear? Yeah. Yeah, I spoke with you regarding my daughter. I need a small advice. I thought I will take a consultation. The scenario, my priority date is May 10th, 2017. So May 17th, 2010. We are applying the EB2. My daughter is aging by the next month. So once we apply the EB2, can we file one I-140 in the normal process just to get the age scenario? Will that work?
That's a very tough question. The underlying I-140 was not been pending for a long period of time. You're just saying that one other I-140 is pending. You're not downgrading and filing. You're just filing under the normal process right now. Is that right?
Exactly. Right now, I'm going with my EB2 right now. That is filing this month.
Yeah, that doesn't look to be that. That doesn't look to be that it's pending though. The other action that you can do, I know it's very tight time right now, and my appointments you might have tried are not available for the next 1 month. The only thing I can suggest you is probably downgrade to EB3 and file an I-140, because in that way the I-140 will be pending for a long period of time for you, unless you convert into premium processing, which you don't want to. That's the only solution I can tell you right now. But if you file the adjustment of status right now, and then now you file another application, that application is not part of the adjustment of status.
Exactly. Right now, the EB3, the final action date is not current for May.
Yeah, I mean, you can try it though. You can try. I'm not, but I will not count on it. If you are going with the strategy, what you said, I will not count on it. Your daughter is already converted to F1 right now, is that right?
Yeah, it is already applied. She got the biometrics done last week, almost.
Did you apply B2?
Yeah, we are waiting for that.
Did you apply B2 for her?
Yeah, exactly. The B2 is this week. Good. We are applying the B2. All that documents, everything is ready.
Throw an I-140 application. It won't harm. It definitely won't harm you. It may or may not help your daughter, but it won't harm you or your family.
Okay. Thanks, Rahul. Thanks a lot.
Thank you so much for calling in. All right, let's take our next caller, Rahul Garu. And in the meantime, we have a question from our viewer, Satish Kumar. He says, hi, Rahul. When can we expect the November 2020 visa bulletin, and what's your prediction on EB2 and EB3?
November visa bulletin, expected any day from now. We have seen the most as 24th. That is the most. As far as prediction of the EB2 and yeah, just hold on for a minute. Sir.
Hello.
Hold on. We can hear you, but hold on for a minute. As far as the prediction of the EB2 and EB3 movement, I would say that there is nobody on earth that is more that went so many times wrong other than this guy by name Rahul Reddy, and I have all evidences to prove that I'm the worst guy in predicting the priority dates. Good, sir. I interrupted you. You have questions for me.
Hello.
Hello, sir.
Yes, go ahead, sir.
Go ahead. We can hear you.
Hi. This is Satish. Yeah, I asked a YouTube question regarding my role. So my labor was in senior developer, and later I was
you told me.
So the question is, my attorney is providing two options: either to amend the H-1B as a senior developer and then file the 485, or another option is to start a new perm in the new role.
I would go for the H-1B amendment and file the adjustment of status right now.
Okay, that's what you would do if you're me.
Absolutely. I don't want to miss this date. You miss this board. You know how long it's going to take for you to get it? You know it. You've been there. So I would
Yeah.
I will not miss the board if I were you. You first,
Okay.
I don't think
And
so
then
the strategy
after-
is correct, but it's better to get in the boat right now rather than stay out.
Okay. One last follow-up question on that. So I've been with the same company since the labor. So the question is, after 180 days, once again the portability, can I switch back to any role, or should it be again the same or similar rule would apply with the EAD?
I would at this point of time, you've crossed the questions, and I don't want you to panic and think too much right now. Stick with the plan that we discussed, and you contact a lawyer in November what to do afterwards. Okay?
Okay. Thank you.
Remember, our goal right now is only one thing: get in the boat. Is that right? Get in the boat.
Yeah.
Okay then.
All right.
Thank you. Thank you so much.
Awesome.
Bye.
So, Rahul Garu, let's go to our next caller. But in the meantime, we have another question from Manju. He says, when will litigations be filed against the interim rule, and what is the time bound litigation result? Do you suggest waiting to file for the H1 extension until that time?
No, don't wait. Litigation is already on the way. The money was already given to the litigation law firm from the organization. I'm one of the founder of 𝗟𝗏. It's already agreed. And there are a lot of other organizations that are going through the litigation process, including Siskin's law firm and some other ALA, a lot of other organizations are going. But of course, predicting the outcome of it is not, we lawyers say we're confident, but can we give guarantee that our litigation process is going to go through? Of course not, we can't. Right. I would not wait for the litigation. I would file an extension. I would like to get a result before the I-94 expires, so that if anything happens, you can file one more extension.
One more extension.
So I would not wait for the litigation result though.
Okay. Makes sense, Rahul Garu. Let's go to our next caller. Hello. Hello. Hello, sir. Please press *6 to unmute your line. This is our caller with area code 865. All right. So while we're waiting for him, we have another question. This is from 𝗓𝗏𝗪𝗀 𝗪𝗏𝗀. It's not a question so much. He says, hi, Rahul, you're doing a very good service to our community, and he really appreciates it. So it's nice to hear that. All right. We'll try and go to our next caller. Okay. While that's happening, let's, hello. Hello. Okay. All right. In the meantime, we have a question from Mr. Viral 30. What is the wage level for OES level 3? Will submit my H-1B extension next month. Will this impact my extension process?
What city is he speaking about? Wage level 3 is, for example, give me 1 second. I have to read this one out. I opened up all different schemes for different cities though. So wage level 3 for Atlanta seems to be 163. Okay. So that's a lot of money. I don't know.
Hello.
Depends on. Yes, sir. Go ahead.
Hello, sir.
Hi.
We can hear you.
Please. I have a question for EB1A category. I'm trying to figure what will be the best resource for me to use for checking what is the criteria for high salary, whether I fit in that or not.
EB1A you are speaking about. Well,
yes, EB1A.
Yeah, it depends on the titles though. I have argued that $50,000 is a very high salary. I have argued it in the EB1A. I would argue, the reason is that here is the argument I would make. $50,000 is a high salary. Unlike the doctors and lawyers, who are in probably because they want to make large amount of money, Nobel Prizes and Oscar awards are not given to the people who make billions. They are given to the people who make $50,000 or less sometimes. So I compare that. Let's say, for example, you're a scientist and you're making $50,000. I would say that most of the world scientists, they don't make $50,000 a year. You are making $50,000 a year. So you would argue that. I would argue that you are qualified for it. And when you're making...
But I am actually a software engineer, and I was looking at OES 90 percentile, Do you still think that would be a good resource?
No, that would still not be a good thing, because remember that you are an extraordinary ability. If you're looking into 95 percentile, you don't look extraordinary for me. You should be top 0.1% to get it. So if you're going to make an argument, OES wages says I'm at the 95 percentage, that's a weak argument. You will have to say that, look, I'm in for a research. I'm not in for earning the money. So
I was looking at the 3 criteria, and I do meet the other 2 criteria. It's just that for the 3rd criteria, I was looking whether I can use.
If you're going to shoot for 3 criteria, that's not a good idea. You should shoot for at least 7 out of those 10. And you must make alternative arguments. If you shoot for 3 and they cut you down on 1, you are gone. If you shoot for 7, they may still cut you down on 4. For each of the criteria, you need to have an alternative criteria. Okay, OES is one argument. They may shoot you down. Then you go to another alternative argument. I'm a researcher. I'm doing this one, or whatever your extraordinary ability on. It's not, I'm in certain field that requires a lot of time to get it. So you have to make different argument. If you're going to shoot for 3, that's not good. That's not a good idea at all.
Okay. That was very helpful. Thanks, Rahul.
Thank you.
Thank you, sir. Thank you so much for calling in. All right, Rahul, let's go to our next caller. And in the meantime, we have another one from our YouTube viewer. He says, one quick question. What is the definition of wage by LCA, whether bonus and benefits is included in the wage calculation?
Good question. Very good question. Unfortunately, bonus is not included in the LCA wage. The LCA wage has to be paid every pay period. If your pay period is 14 days, so let's say, for example, if you have $120,000 and you are getting monthly salary, every month the salary paycheck should be $10,000, period. If it is 1 month 8,000, another month 14,000, not acceptable. So bonus is not included in the LCA wages.
Okay. That makes sense. All right, let's take our next caller. So please *6 to unmute your line. This is for area code starting 865 or 330 in this case. Hello. Sir, area code 330. Hello.
Okay, I read a question in the meantime here.
Yeah, go ahead.
Good. Oh, me?
Oh, no, I was going to read another question, but I forgot you.
Yeah. No, I have a question. The guy has, I have an I-140 approval with company A. I'm with company B. I can't go back to with company A. What should I do with company B? Have them file a labor and file an I-140? Well, that's a question that came from YouTube here. No, you don't have much options other than having your company right now to file a perm and I-140.
Okay, all right. Okay, let's try a caller again. Sir, please press *6 to unmute your line. This is for the caller with area code starting 330. In the meantime,
we have our Reshma Pavarkar. She has a question.
Before that, we have a few more that have asked a few questions.
Go ahead.
This is from Satish Kumar. He says, please explain about third-party worksite. Oh, wait. Hello?
Hello? Yeah.
Yes, sir.
My existing H1 is on a level 4. For extensions and for perms, can we downgrade it to a level 2 or level 3?
Your existing is level 3, is that right? What you said?
Sorry?
Your existing H-1B is level 3, is that right?
Yeah, currently it's level 4. Can we downgrade it to level 2 or 3?
Depends on the,
and also for H1 extension.
We don't see, and if it can be articulated properly by your company and your lawyer, we don't see that as a problem.
Okay. So is there a rule saying that, okay, if you are 10 years experience, it should be a level 3?
you can have 20 years experience, but I only need to clean my tables. Okay, so I will only pay salary for cleaning my tables. You might have a doctorate degree. I don't care. So it's not how much experience you have. It's what the position requires that will determine the salary. Okay?
Okay, thank you.
All right. Thank you, sir. Thank you for
Thank you.
calling.
Yeah, a lot of people have a lot of experience. So what? The position requirement is the main thing, not what, how many years experience you have.
That makes sense. Rahul garu, so I'm just going to continue our previous user's question. He says, please explain about third-party worksite. Is CTS, TCS, Wipro employees working at client location will be considered as third-party worksite?
There are two things. These major companies that you're speaking, Nitya, there are sometimes they're implementation partners. There are sometimes they're pure consulting, though, third-party placement, though. The way the regulations have designed, though, they looks to be that they will consider even an implementation partner as a third-party placement because they are working at a third-party site. So that looks to be the way how the regulations are interpreted. We'll see how these regulations are targeting the companies that he was speaking about.
Okay.
That's the whole purpose of this regulation.
Makes sense, yeah. That's true. All right, let's go on our next caller, Rahul garu. Hello. So area code 626. You're on right now. Hello. All right, while we're waiting for him, let's go to our next question. This is from Sai Hosuru. He says, we received H-4 visa approval. It has only extension dates, not the I-94 details in it. Is this expected change?
The I-94 doesn't have the expiration date. Is that what he said?
He says, one second. He says it has only the extension dates, not the I-94 details in it.
In the H-1B, if
H-4 visa.
H-4 will come with an I-94. There's no chance that it will come without an I-94. At the bottom of it, the I-94 will be there.
Okay.
So I'll be very, no, there is no, I have not seen anything with a H-4 without I-94 yet.
All right. I guess for Sai, maybe just like show the approval around and see if anyone can help you identify where the I-94 details are on the
It'll be at the bottom left-hand side.
Okay, awesome.
But sometimes what happened, Nitya, is that the original approval goes to the lawyer. The copy of the approval comes to the individual, though. So he may have been confused. Hey, I got this one without I-94. That looks to be the confusion that he has.
That makes sense. Okay. So in that case, he just has to reach out to his lawyer and get...
Right. Right now, lawyers are busy with other things. They are not...
That makes sense.
I understand. Yeah.
I can imagine. All right, let's go with our next caller. Hello.
Hi, can you hear me? This is Ashish.
Hi,
Ashish, go ahead.
Go ahead, please.
Hi. Hello, Rahul. I'm a big fan of yours. I always follow your YouTube videos, directly jumping onto my case. In 2016, I joined a company. I had EB3 I-140 in December 2010 before I joined it. Now I moved to company B. They filed my LCA at the time of joining H1 transfer with computer system analyst. But they filed my I-140 with software developer application. That's how the SOC code says. And after that, they kept on extending my H1 on computer system analyst. And I'm filing 485 now. Will it create a problem or is it a normal thing?
No, sir. It does not create a problem. You're fine. Absolutely not a problem. It's a natural increment. I don't see any problem whatsoever at all for you.
Okay. I have a quick question. I heard about the marrying with EAD. That's how you coined the term. My wife has had a H4 EAD and recently my H1 got approved. So I'm thinking about extending her or applying for H4 EAD as well. So do you recommend that or do you recommend to use the EAD out of a 485 which I'm going to take? Because I would refer back to the video. I would refer back to the video that you saw.
it's not an easy answer to say yes and no in 1 minute. That's the reason we presented in 1 hour and we defined what a marriage is. And, once you get married, how hard it's to get divorced. I have described it very clearly. I would refer that to the video.
Yeah. So
if you want in your particular scenario, if you want to discuss about it, it's not going to be 1 minute discussion. I would recommend that you contact our office in December. We will go through. Until that, you are not getting the AOS EAD anyway.
Okay, so she using the EAD out of 485 is like getting back to that case, right?
Right. She's marrying. Yes.
Okay.
She's getting married to the AOS.
Thank you.
Thank you.
Thank you, sir.
Thank you so much.
Rahul Garu, at this point, I think we'll go for a short commercial break and we'll be right back. So guys, stay online and keep posting your questions so we'll get to them as soon as we can. Okay? Thank you.
Question. Is Trump winning the
ఎక్స్చేంజ్ 𝗜𝗩𝗀𝗃 బ్యాలెన్స్ మ్యామ్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్ 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
ఇది మా హీరో అల్లుడు కోసం ఫిట్ గా ఉంటుంది.
పర్ఫెక్ట్ గా ఫిట్ అవుతుంది. ఇది మైండ్ డైమండ్ 100% క్వాలిటీ.
సార్, ప్రతి మైండ్ డైమండ్ న్యాచురల్. ఇంకా మేము 28 క్వాలిటీ టెస్ట్లు చేస్తాం.
28 టెస్ట్లా?
ప్రతి డైమండ్ జ్యువెలరీతో పాటు ఇంటర్నేషనల్ ల్యాబ్ సర్టిఫికేట్ కూడా.
కళ్ళు మూసుకుని మీ హీరో కోసం వజ్రాలను తీసుకోండి. ఇది మలబార్ ప్రామిస్. ప్రామిస్ ఇస్ ఎ ప్రామిస్.
Boomi Instant Coffee is made with 100% pure coffee beans guaranteed. It tastes and smells like fresh brewed coffee without the weight. Our proprietary low-cycle extraction process maximizes the flavor and aroma, making each sip equally delicious. We're committed to serving you affordable 100% pure coffee with no additives or artificial flavors. Try a cup and join the millions worldwide who enjoy Boomi every day.
Sunshine Wealth LLC. Conquer your financial future.
We came to this country with big dreams. We have been working day in, day out. Our big dreams seems impossible to reach. Let's not give up hope. Let's work together to create your financial freedom roadmap. We care about you. We care about your future.
For more details, log
Welcome
on.
back to our talk show with the experts. We have our expert here, Rahul Reddy Garu. Reddy Garu, we're going to continue with our show today, and we already have another caller online. Hello, sir.
Hello.
Hello, sir. Chapandi, we can hear you. Go ahead with your question.
Okay, can you hear me right?
Yeah.
Yes.
Okay, so this is regarding the prevailing wages, whatever the recent interim rule. So one of my friend, he applied for new H-1B and he got a RFE, okay? So now he has approved LCA for a certain wage level, right? That is whatever the previous. Now my question is, there is any effect on his H-1 approval with new LCA?
Not on
wages.
him. Not on him.
Okay. And one more question. So even my case, I got my H1 approved with a certain LCA. If I will go for visa stamping in India, then this whatever the new rule
no, it is not effective. It will not affect. Right? It will not impact you for your stamping. When you go for extension, though, it will impact you.
Yeah, extension or amendment, it will go impact, right?
Absolutely, it will.
Okay. So there is any impact on GCLCA level? Like if I'm going for 485 to apply.
Oh no. If you're applying 485, that doesn't affect you.
Okay. Thank you, Rahul.
Thank you very much.
Thank you for calling in. All right, Rahul Garu, let's go to our next caller. But in the meantime, we have a question from 𝗜𝗩𝗘 He says, for I-944, what do I provide for the credit score for kids, their dependents on me?
Just tell them no credit score. That's it.
Okay. So Avneet, if you're watching this, no credit score. All right, let's try with our next caller. Sir, area code 865, please press *6 to unmute your line. And in the meantime, we have another question. This is from AF Virginia. Says, I'm electrical and electronics engineering with 15 years plus experience. Applied H-1B for new solution architect job and got an RFE saying you have not established that the beneficiary is qualified to perform service in a special occupation.
Specialty occupation. Yeah, we have been seeing these RFEs though. What need to be done is that obviously you need to get an education evaluation again one more time. You also need to get an expert evaluation done about the position. That expert evaluator must be an assistant professor or professor in a current university right now working. And this assistant professor or professor should be having a phone call with you and your employer before he gives an expert opinion. These are the things that, minimal things that I would recommend that you do. Otherwise, you will be risking your H-1B.
Okay, thank you.
Hey, do you hear me?
Yeah, I'm
yes, go ahead.
you. Go ahead, sir.
Hey, Rahul, thanks for taking my call. See, I have my receipt number, which dates back to September 2nd. So I think I don't have, these new rules does not have any effect on my wage level. Would the new H-1B rules will have any impact? Not the wage, the specialty occupation and all.
No, they're going into 60 days from now. You already filed an application. You're good.
Okay, even if I get RFA, it will not have any impact.
No, should not.
Okay. Thanks a lot. Thanks a lot, sir.
Thank you.
Thank you. All right, Rahul, let's go to our next caller. To all our callers, please press *6 to unmute your line. Hello?
The new H-1B rules will have any
Please mute your TV.
Not your telephone.
Not your phone line, just your TV. Press *6 to
Hello?
unmute your phone line. Hello,
Yes, sir, go ahead.
Yeah, we can hear you. Go ahead.
Hello?
Hello,
Yes,
sir.
go ahead, sir.
We can hear you. Please mute your TV line though.
Yeah, hello. My name is Venkat. I'm filing my I-145 under EB2 category. So I have one question. So I am in this country since 2006. I spoke with you, Rahul, a couple of times regarding one suspicious email. My question is this time, in the year 2008, I went to India, I visited my family and I stayed there for 6-7 months. So is it a problem? In the year 2008, I stayed in India for almost 7 months.
No.
So is it a problem filing for 85?
No, it's not a problem. Number one is they're not asking you anything about that history at all. They're only asking 5 years address history, 5 years employment history. So nothing pops out there. You're good.
All right. Another question. It's for my brother-in-law. He filed his EB1A category. He's a medical doctor. He filed his I-140. So he's thinking about premium processing. Do you advise going for premium? Basically, he applied in June. His priority date is 2017.
Why did not he apply? His priority to 2017. Did he already had a EB2 approval?
Yeah, he already had a EB2 approval. Now he moved to different employer, different hospital. So they filed in EB1.
I don't know why he never converted into premium processing. He was eligible for premium processing. He should have done premium processing. The EB1C people are not eligible for premium processing, but this guy is eligible for premium processing. He should go for premium processing.
Okay. All right, Rahul. Thank you so much. I appreciate it.
Thank you.
Thank you, sir. Thank you for calling. All right, Rahul, let's go to our next caller. And in the meantime, we have a question asking, will the new wage law affect the EB2 to EB3 downgrade in any way?
No, it does not.
Okay. All right, let's take our caller really quick. Hello? Sir, area code 5. Yeah, hi. We can hear you,
sir.
Please go ahead.
Yeah, thank you very much, Rahul sir, for helping the community with this. My question is, my parents are on green card and they just went to visit India before the COVID situation hit. So now it's almost like 9 or 10 months they've been out of the country, out of US. And we are looking into what remedies do we have.
You know that they can come within 1 year. The problem is if they don't come within 1 year, they have to get a permission from the consulate to enter into United States. It's called returning resident. When you apply the returning resident, they have to show very clear and convincing evidence that this 1 year trip was an accident and that extended because of the COVID situation. But her previous stays, how long do you have a green card though?
It's been a few years, like 5 or 6 years, and they make sure that they are in the US for 6 months.
Okay, that's
year.
not, did they file the income tax returns?
No, they don't.
They need to. Every green card holder is supposed to file income tax returns. Even if you have a zero income, you just file zero in it and you file the income tax returns. So I would recommend that you contact a lawyer if they have plans to come back after 1 year. Before 1 year, there shouldn't be any problem. But after 1 year, don't just apply the returning residence though, application. You need to show all evidence, filing the income tax return, showing the residence, staying in this country, any driving license, any certain other things. So show all the evidence and submit it to get the returning resident. I would advise, I mean, I'm not a doctor. I'm not going to enter into the COVID situation, but if they can, coming before 1 year would be much. So you have to discuss, you know, you need to look into, do I listen to doctor? Do I listen to lawyer? I mean, it's, you know, it's not an easy choice. Maybe I'll listen to the doctor if I were you, but I'm a lawyer. I'm not a doctor of you. So it definitely will be easier for them to come before. Afterwards, it's going to be harder for them to come into the United States.
Okay, thank you very much.
Thank you.
Thank you, sir. Thank you for calling in. All right, let's take our next caller. But in the meantime, we have a question from Rajesh. He says, lost job and applied for a B2 visa. He says, can I extend it? Will there be any consequences later? As I didn't have a job for the past 7 months.
Yeah, it's going to have consequences.
All right.
I would not recommend that he extend it beyond the 6 months period of time. Because of the COVID, he did it. If he extends it, he will have hard time coming back into the United States at a later date for him.
Makes sense. Okay. All right, Rajesh, if you're listening to this, you have your options out. Let's go to our next caller. Hello. Hello. Sir, area code 917. Yeah, please press *6 to unmute. Hello, sir. Yeah, we can hear you.
Hello.
Yes, sir. Go ahead.
Yeah, hi Nitya garu. Hi. Hi Rahul garu. Meeku advance Dasara శుభాకాంక్షలు అండి.
Thanks, Andy.
మా సిస్టర్ గురించి కాల్ చేశానండి. తన ఫస్ట్ H1 అప్రూవ్ అయింది. తను ఇండియాలో ఉంది. వాళ్ళ ఎంప్లాయర్ ఈ మంత్ ఎండ్ కల్లా ఒకవేళ ఆన్ సైట్ కి రావడం కుదరకపోతే విల్ బి అవుట్ ఆఫ్ జాబ్, విల్ బి లూజింగ్ యువర్ జాబ్ అని చెప్పారు. సో
వాట్స్ ద ప్రాబ్లం?
ఎమర్జెన్సీ అపాయింట్మెంట్ కి ఆప్షన్ లేదు.
So let me ask you this question.
There are any other options?
Let me ask you this question though. Is it is this the first H-1B? Is it through lottery or is it second H-1B?
H-1B through lottery.
Okay. Was she here at the time?
Convert అయిన తర్వాత
Was she here at the time the H-1B was approved? Why did she leave?
Yes, sir. Yeah.
When did she leave?
She left around July. Consular processing approved. We already reached out about this, like we talked.
Okay, the day one CPT.
Like previous employer. No, sir. Previous employer didn't apply amendment, and she has been working and transfer apply చేసినప్పుడు.
Wait. You're confusing now. You're saying that previous employer didn't file an amendment. That means that this is not a quota H-1Bs, right?
This is a H-1 transfer, Andy. It's been approved in consular.
So it's definitely not the first H-1B. It is not a quota H-1B. Yeah, okay. That's not a problem. Have get another job and get her here on some other H-1B.
Okay, so that's the only option right now, Andy.
That's the only option, yeah.
We're going.
Okay. Okay then, thank you.
Can we request for
was...
Dropbox, sir?
No, she's not. You can request for
no,
emergency, but not
Dropbox.
Not eligible for Dropbox.
Emergency, H1's emergency open then?
Yes, they're open, but you have to prove real emergency. You can try that one.
Okay.
Okay, then. Sir. Thank you.
Thank you.
Thank you for calling in. All right, Rahul Garu, let's take our next caller. And in the meantime, we have a question from our viewer, Nikhil. He says, currently I'm working with company B and my I-140 got approved in 2017 with company A and is still active. Can I use my existing I-140 for my future H-1B extension after 6 years?
Yes, you can. If the I-140 has not been withdrawn before 180 days, practically that I-140 belongs to you. You can keep on extending with a different company. It doesn't have to be the same company. You can move to company B, company C, company D, company F, using the same I-140 approval of company A. Once it passes 180 days, that is statute to you. It is ever live for you for most purposes other than filing the green card purposes, adjustment of status purposes.
Okay, that makes sense. All right, Rahul Garu, let's get to our next caller. Hello? So area code 920. Hello? Okay, while we're waiting, we have another question from our viewer, Reshma. She says, what are the most common AOS RFEs in the recent times?
AOS RFPs are almost a must for everybody. One of the reasons is that AOS takes long time for adjudication. So there has been a lot of employment changes. One thing is that the medical dies. I mean, if you submit the medical expires. If you don't submit the medical, then you have to submit the medical. So RFE is a compulsory thing. One thing is medical. The second thing is medical is because medical expires in 2 years if you file it. And if you don't file it, they need a medical. That's RFE. Second thing is they will ask you to re-verify if you're still working with the same company or not. They want the company to submit the 485J supplement because adjustment of status takes about 5 to 10 years sometimes. So they want to see if you're still working for the same company. If you're not working for the same company, can you file a 485J supplement? And can you substantiate that you are working in the same or similar positions? These are the most common RFEs. Then there are other RFEs that comes in, but these are the most common RFEs that we get it.
Okay, that makes sense. Thanks, Rahul Garu. Let's go to our caller. Hello? So area code 920. All right, let's move on to our next caller then. Hello?
If you don't submit the medical, then you have to submit the medical.
You have to mute your TV
Hello?
set.
So can you mute your TV line?
One thing is medical. The second thing is...
so area code 425. Hello?
Hello?
Yes,
Yes,
sir.
sir.
Area code 425. Do you mind muting your phone, not your phone line, but your TV line? Please press *6 to unmute your phone line.
Hello?
Hello, sir.
Yes, sir. Go ahead.
Go ahead. We can hear you now.
Sir, very good evening, sir. Sir, actually, my wife L2 work చేసింది 11 months. తర్వాత H1 ద్వారా వర్క్ చేసింది. ఆల్మోస్ట్ వాళ్ళు నెక్స్ట్ ఎక్స్టెన్షన్ వెళ్ళినప్పుడు L2 కన్సిడర్ చేస్తారు 6 years డ్యూరేషన్ లో.
The time period that she spent on L2 EAD will not be counted towards the 6 years or 5 years, whichever period you would count. No, that period is not counted. It's freely given to her.
Okay. Thank you, sir. So yeah, that is one thing, sir. One more thing here. My firm applied on June, but my actually concern is here. January is the last, my 6 years is complete. In generally, how many days is taking?
You should be getting the approval any day right now. The last time I checked on the labor approval, we got it for the June 1st week and some May last week. So you should be getting approval any day now.
So that's what I heard. 4 months it is taking, but I don't know will it go for longer just because of this COVID.
No, it's not going. COVID. They're all working from home before anyway. They're not working from, and previously they used to go to ballpark and soccer games and all those things. Now it's all there. They're sitting at home. So it hasn't gone. So COVID is working good for you. So, so, and they're not going vacation. They're not going to Las Vegas. They're not going to Disney World anymore. So, okay. Thank you then.
Thank you, sir. Thank you so much.
Sir, following one more question. Sorry, sir. Actually,
we have a ton of other callers also waiting. So if you can, then please call us back next week. Thank you. All right, Rahul Garu, let's take our next caller. Hello. Hello, sir. Area code 920. All right, Rahul Garu, one of the questions is from Rajesh Gupta. He says, why is everyone talking so much about the credit score? You know, so he wants to know about the importance, like what.
No, it's not important. They saw something, they see this credit score, they say, oh, it's not. This 944 is designed for people who have really poverty-stricken people, whose incomes are in 20,000s or 30,000, their families are very poor. Specifically for the employment-based, I don't know why they put it. It's creating panic among the people. If your family income, Mr. Gupta, is more than $60,000, even if your credit score is low, I'll be very, very, very surprised if they would deny your application.
Okay, makes sense.
My credit score is so low because I don't have any debts. So it doesn't mean, anything bad. Okay?
Yeah, I think people are, getting worried, but
unnecessarily panicked, and there's a lot of rumors flying around. This chit chat. Oh, your credit score. Nobody cared about those things before as much, only for the loan purposes. Now they are worried about it. No, I'm not. I'll be very surprised if your family income is $60,000 and you have maybe $2 million loan though. I may look into it carefully. But if you have $60,000 as family income, you have a $1 million loan, I'm not worried for you.
Correct. Okay. All right. Let's take our next caller. Hello. Hello, sir. All right. Let's move on to our next caller then. And in the meantime, let's go to our next question. Hi.
Hi, good afternoon. How are you?
Doing good, sir.
Thank you, sir. Go ahead, please.
Yes, a question. I know Rahul spoke about getting married to EB2, right? So my question is, if my lawyer decides to file both I-485, EAD and advance parole, is it possible to retract them before my case is adjudicated?
I want you to watch the video we did 2 weeks ago with Emily Neumann. By filing an EAD and advance parole, you are not getting married to this application. You are just flirting with this application. When you use it, you get married.
Okay. So if I still stay on H1, I won't be using it. All right. Thank you.
That's right.
I appreciate your help. Thank you.
Thank you, sir. Thanks for calling in. Let's go to our next caller. Rahul Garu, there's another question from Radhe Chandra. He says he has a 3-year bachelor degree followed by 3 years of PGDCA from India, and he's filed for his EB2 140 and a master's plus 3 years experience. Will USCIS raise a red flag because of my 3-year degree that was submitted in 2011?
He said 3 years PGDCAs, right?
Yes.
Oh, yeah. That's a good. I wouldn't have gone with this guy for EB2 at all. Maybe I would have filed it in EB3 and maybe I would have tried to convert it, which I failed many times for this. There's a good chance that he will get an RFP and it may be denied too.
Okay. All right. Let's go to our next caller. Hello. So area code 862. Press *6 to unmute your line. *6 to unmute your line. Okay, while we're waiting on this caller, let's go to our next question. Hello?
Hello, can you hear me?
Yeah, I can hear you. Please go ahead, sir.
Yeah. Hi, Rahul. Thank you so much for your service. You are helping a lot. My question is, right now my H-1B is getting expired in the month of January 2020, 1st. And my company, they filed LCA, and maybe somewhere around last week of September or first week of October. And they didn't file I-129. But they didn't file I-129. So my question is this a new rule is going to impact anything on my extension?
No, not you. Because luckily you filed LCA before October 8th, not after October 8th. So you're good. The last day my team worked a lot and I to file as many LCAs as possible before October 8th. So we're good. You're good. It's not affecting you right now.
Thank you, Rahul. My attached question to that is, it's a related to so they denied even for my downgrade EB2 to EB3. Mine is June 2011.
Who denied it?
So my company didn't accept for downgrading to EB3.
Thank you. I was like very surprised. We normally don't do EB2 to EB3 denial. So I don't want people to be under assumption.
My priority date is.
I got it. So it's a company's option, though. I mean, it's a company's option. There is nothing you can do or I can do to force them to convert into EB3.
So June 2011 is my priority date. So they were saying that they are optimistic on November EB.
Doesn't matter, but there is nothing you and I can do right now. So let's not discuss on the things that are not in our hands.
So it looks like I'm missing the boat. All right. Thank you.
At least it seems maybe the boat will come. We don't know. But for October, you're missing it.
Hopefully soon, fingers crossed. Let's go to our next caller, Rahul Garu, and then in the meantime, we have another question. This is from 𝗟𝗲𝗃𝗧 Creations. My I-797 is expiring in the last week of Jan of 2021. My company says they've filed LCA already, must be around first week of October, and says it won't impact.
It won't impact.
June 2011, I guess, is priority date. Downgrade is denied by my company. Any suggestions?
Downgrade denied by the company. The word they're using is, no, downgrade is not denied. The company refused to do the downgrade. There's nothing we can do about it. As far as the LCA is concerned, since the LCA is already filed, he's safe. He's not subject to the new labor dual wages.
Makes sense. Okay. All right. Let's go to our caller. Sir, please press *6 to unmute your line. This is for area code 847. Hello?
Hello?
Yes, ma'am.
Yes, go ahead.
Okay.
Hi, Rahul sir. My question is about, you say in your video every time, if your wage is 60,000 and credit is bad, but you are okay. But my husband's pay is under 60,000. So, but our credit is excellent. So
that's fine. You're good.
Okay.
You're good, ma'am. You're good.
Okay. And one more question. I take Medicaid in my pregnancy time. It's count in a public charge. I called DHS. They don't find my record. I called baby and mom who I take that time. They said you are the insurance is state level, not a federal. So it's count in a public charge or not?
When you say Medicaid, what do you mean by Medicaid, though?
Okay. They say it's MCO program, but it's covered by state.
MCO.
Yeah, MCO.
Okay. I don't know much about that. I'm not proficient with that, though. And I would say that at this point
I called 2-3 times in the office, and they say it's covered by the state. And DHS don't find my record, any insurance records, anything. They have my kids in there, but not me.
Reshma, I have to admit that I'm limited right now. I have no knowledge about this MCO. I don't have knowledge about it. I'm sorry about that.
Okay,
because
so we can put the column and we put
I
the
would
dates
not-
on
I
the
would-
944 form?
I would recommend that you contact your lawyer, go over with him before you put anything on that.
Okay. Okay. Thank you so much,
Okay.
sir.
Thank you, ma'am.
Thank you, ma'am. Thank you so
Thank
much
you.
for calling in. And that is all the time we have for today. So thank you, viewers, for calling in, posing your questions on YouTube and Facebook for us. Rahul Garu, thank you so much for yet another fabulous episode.
Thank you, Nitya Garu. Thank you,
Answering
TVASIA.
everyone's questions.
Sure.
So for the viewers, please tune back next week, same time, same day, and there'll be lots more questions and lots more things to discuss. And until then, thank you and have a wonderful week.
Thank you.
Thank you, sir.
Went without any problem.